But it was zealous. So the opening statement of the defense, and again, Shanley just shared with us the objections being made by the state during that. We know trial skills-wise, you don't object during the opening statement or closing argument because it could be a bad look for the jury unless you really have grounds that you need to protect and you need to stand up and object. And part of what he was trying to say was to the jury, you had your chance. You could have gotten out of this on Monday. The objection was sustained. What's your position about addressing what the jurors could or couldn't have done, or the fact they're serving on the jury? Should that be allowed during opening, in your opinion?
I think when you're in a Hail Mary situation, you have to throw everything you can at the fence. It's very, very, very out of what's the word? It's very subpar if you're an attorney and you have to object to an opening statement or a closing statement. It rarely happens, but we see it happen all the time in situations where you're either desperate. We saw it in the eye drops murder case, right, where the prosecution objected to the opening statement of the defense attorney who said it's impossible to die from Visine, right? And it's not possible. They had to object, right? And so we see it happening. And so in this situation, when they were objecting to these statements, I think they had no choice but to inform the jurors, hey, listen, you know what? We're probably going to lose this case, but we want you to know that you shouldn't have done X, Y, Z. So I do think they had to do it just because of the overwhelming evidence against their client.
And they took that chance.